before we get to that, I want to resolve one issue. As counsel and the parties are aware, one of the jurors was spit upon during the trial of this matter, and it's my understanding that he had communicated yesterday with my secretary about the taking certain tests to make sure that he didn't get any kind of infection or anything along those lines as a result of that. And I'm not quite certain what the process would be, but considering compelling the defendant to proceed with some sort of blood test or some form of test while still at the Lorain County Correctional Facility before he's transported to the institution, so that that can be determined whether in fact there was anything potentially infectious that he might have gotten in that regard. Anybody give me some insight as to any issues that the court may need to address before I can order such an act from the state's perspective?
I believe that's fully within the court's rights.
And from the defense?
I think the law is pretty clear that you do have the capacity to do so.
All right, okay.
Of having others' cases thrown out, so I can ask the witnesses further questions about my case that could prove my innocence. And when I try to ask questions that could open the door for other robberies, my lawyer told me it'd be suicide. And I think with him having 30 years experience, he knew he was supposed to get those cases taken care of, so I went in front of the jury with just one case. And life without parole don't sit well with me. So I'm going to request the death penalty. And I have two ways I prefer to be murdered. One is to be crucified in front of the courthouse for all the sins, all the convicts throughout the world.
It's as follows. On count one, no sentence by the court due to election by the state of Ohio. On count two, life in prison without the possibility of parole. Count three is 10 years in prison. Count four, no sentence issued as this count is a lesser included offense to count two. Count seven, no sentence issued as this count is a lesser included offense to count two. Count eight, 4 years in prison. Count nine, no sentence by the court due to election by the state of Ohio. And count 10, no sentence issued as this count is a lesser included offense to count two. The defendant is remanded over the care and custody of Lorain County Sheriff's Office for transfer in accordance with the decision. Good luck to you, sir. Good luck to you, folks. For what it's worth, I wish to reiterate from the doc's perspective, I appreciate the calmness that's been admitted by the family in this regard. It's much appreciated.
Twilight experience in my life. I thought I was in the outer limits, the old outer limits show. I'm going, don't adjust your set, we're in the outer limits. This whole thing, 3 years, it seems like an eternity. As far as it being over, nah, that's not over. Every passing day, you think of something that that David may have done or something like that. That's all gone, all lost. I don't know what more to say to you guys. Just thanks that you do respect our privacy. Catholic could accept the death penalty, and you never really got back with me on that, but but in my heart, I think just the thought of never being able to ever do anything, to ever see a sunset again, to ever to witness anything in this life would be imprisonment enough. Sometimes I wish they almost could have scientists take and study the brains of people like that to see what chemical imbalance is there that causes them to do what they do.